Geofrey Kazinda was principal accountant in the office of the Prime Minister between 2009 and 2012. He was arrested and convicted on charges of abuse of office, conspiracy, false accounting, and causing financial loss. In November 2020, he was sentenced to 15 years after he was found guilty of illicit enrichment when evidence showed that he was living beyond his known income. He had acquired properties valued at 4.6 billion shillings while earning 15 million shillings annually, including allowances. Today, Kazinda appeared by teleconferencing before three justices of the Court of Appeal, who included Justice Catherine Bamgemerere, Frederick Egonda Ntende, and Christopher Madrama. Kazinda had appealed against the 15-year sentence on 12 grounds.
The appellant's argument that the trial court should have discontinued the proceedings against him in High Court Criminal Case number 004 of 2016, from which this appeal arises, is baseless. We therefore find that the decision of the Constitutional Court is not a bar to the prosecution of the appellant on the current charges in this appeal.
One of the top reasons as to why Kazinda appealed against his sentence was the fact that at the time when the IGG prosecuted him, it was not fully constituted. It is a requirement by law that the inspectorate must have a judge who should resign from the judiciary and also have two inspectorate generals. The Court of Appeal has, however, quashed his ground.
The prosecution of the appellant's case commenced in 2016 when the inspectorate was fully constituted. We find that the appellant's allegations are unfounded.
The appellant further argued that while calculating his income when he was the principal accountant of the office of the Prime Minister, the IGG did not consider wealth acquired 10 years before.
The appellant did not declare any savings or other forms of income to justify the sudden increase of wealth.
On the issue of hiring a suite at a hotel in Kampala valued at 210 million shillings through an agent, prosecution adduced evidence linking him to the luxurious lifestyle.
The bills were in the names of Kamumvi Charles.
Of the 12 grounds that Kazinda gave for consideration, 9 were quashed. However, while delivering the judgment, the justices said that Kazinda was a first-time offender and the judge ought to have considered that before giving him a maximum sentence of 10 years for each of the 3 counts of illicit enrichment, which she later reduced to 5 years each because he had been on remand for 4 years and 5 months.
The appropriate sentence would be 3 years on count 1, 5 years imprisonment on count 2, and 4 years imprisonment on count 3 to be served consecutively, one after the other. However, we must deduct from the aggregate total of years to be served the time of 4 years and 5 months that the appellant spent in pre-trial custody in compliance with Article 23(8) of the Constitution, and the balance thereof, 7 years and 7 months, shall be served from the 6th day of November 2020, the date of his conviction.
Kazinda still has 6 years and 2 months to complete his sentence. Sudhir Yarhanga, NTV.